Good morning, everyone. Thank you for joining us for another great spotlight session. Today we have our very own Professor X, Jeff Fesco, who is the director of CJREI, our real estate school, as well as our broker of record, and is a wealth of knowledge when it comes to real estate and real estate legalities and practices and all that types of things. So I'm going to let Jeff go ahead and take it away. Thanks for coming, Jeff.
Thanks. Thank you.
Mhm.
So, good morning, everybody. I was thinking about a topic for today, and I think the topic of today really is, what are those things that people talk about when they get together as real estate agents or as attorneys for real estate, or what are those topics that seem to be unresolved or unresolvable or perplexing. And we're still sort of reeling from the changes that came about from the NAR lawsuit. We're still reeling from the changes that have been made by the New Jersey Real Estate Commission last August, which are, only 7 pages long, but boy, not like the easiest material to digest, right? We still have questions, and there will be questions. People will realize that, wait a minute, that maybe this and this and this don't actually, make sense. And so we need to maybe tweak the law a little bit as we go forward. And then there are these unwritten rules or policies for your brokerage. We've always said, as we look back on the basic education of real estate, you've got all of these federal laws that are sort of superseding. You have fair housing and antitrust and all that business, that emanates from Washington. And then you have the state laws, the New Jersey statutes annotated, the New Jersey Administrative Code, all those rules and regulations that are promulgated by the state of New Jersey that we have to adhere to. And they're voluminous, 150 pages of law, and it changes and it's tweaked all the time and so on. Uh, and then you have what? The policies of your brokerage. You know, Anybody ever read the rule book there? Do we know what they are? I mean, there are some basic rules. I know one, for example, in our brokerage, and that is a no, very low tolerance for a hostile work environment. So if somebody were to say something, nasty about another colleague of yours, I know Raj has a very low threshold, for that kind of stuff, and it should be that way, and it is that way in many organizations, But what are those other rules and regulations? So, coming fresh from the visionary quadrennial meeting, a new word for all of us, yesterday, some of the talk that occurred, a lot of people come to me and ask me questions, right? I think I try to stump Jeff, with questions, and surely there are some gray areas that maybe there aren't definitive answers to. So I wanted to sort of share with you some of the discussion that we had. And the first one was around the issue of charging MLS fees. Now, in the past, when we filled out a agreement to sell somebody's house, right, the standard seller's agreement, there was a slot in there for the amount of percentage or amount of money, if it could be a flat amount, that we would be compensated for as a seller's agent, right? And then what else do we have? We negotiated the buyer's agency fee as well, right? And that's what was all the hoopla was about when we got into this NAR, National Association of Realtors lawsuit. Oh, it's an antitrust violation to have the seller, you know, pay the buyer's agency fee at the moment when we take the listing. Okay, well, I don't get that, but all right. I guess I can see it. I don't think it's right, but it's why not? Somebody's going to pay it, right? So why not settle that right up front? So we're no longer allowed to do that. Everybody knows that. But what about that other slot on that form that doesn't exist anymore that said, MLS fees? Now, at our brokerage, you pay your $98 a month for your fees, but also what's that other little fee that you pay? It's that $25 a month, for the listing, right? And for me, I have a land contract. If I have a piece of land for sale, it may sit for a year, 25, 25, 25, 25. And, it seems reasonable to try to recoup some of that, from the buyer, right? And so in the past, we always had the slot, MLS fee, right? So when you went to the closing, you'd see that plus or minus MLS fee. So you'd have a commission amount, which is usually based on a percentage, could be flat. And then you'd have that MLS fee that you could recoup at the end. And so a lot of the, listings that are starting to close or have closed after that MLS decision, after that change in the law last August, have that MLS fee sort of still floating around in the system there. So the question is, does the pre-negotiation of that MLS fee with the seller constitute, the same violation of antitrust that the predetermination of the buyer's agency fee constitutes? So it's like if one is not allowable, then the other one shouldn't be allowable either. But here's the problem. They were very clear about the fact that you can't pre-negotiate the buyer's agency fee and publish it on the MLS, right? But nobody's talked about that MLS fee, right? It's absent. There's no ruling on that anywhere. So Raj and I had a conversation about this a few months ago. We found a internal memo, that was issued by Weichert Realty, and it was a memo to all of their, I don't know how many hundreds or maybe thousands of employees. Do not charge an MLS fee to your buyer agents. Period. That's it. Why? Well, if the NAR was sued for, was it almost $400 million, and there are copycat lawsuits all over the place for this antitrust violation, which is pre-negotiating that buyer's fee. Are we opening ourselves up to the possibility of a lawsuit by charging those fees to buyer's agents? So it's not written in New Jersey statutes annotated. It's not written in New Jersey administrative code, that 150 pages that we have to adhere to as real estate agents. Where is it written down? It's not written down, but it's considered best practice to protect and preserve your brokerage from being sued. And it's a few hundred here, a few hundred there, maybe. Now, I remember when I first started, I worked with a closing up in Bergen County, and the agents up there charged $400, for these fees. It was in the MLS. Every time you looked up a Bergen County listing, it's 400, 400, 400, 400. So, for us, we always used to see $50, $25, $100. It was sort of a nominal amount of money. So it wasn't like, it's not like for us, in the Garden State, scenario here. that we're giving up a lot of money. But for those agents up north, or maybe other parts of the state that traditionally have charged a lot more, there is a possibility, that you would see, somebody being a little bit upset that they're losing some income, losing some revenue. So I just want to sort of talk about this and say, listen, this is not the law, but it's considered best practice, and it falls under that umbrella of what your company says you should and shouldn't do. Maybe it's like, you know not the best example, but if you have a policy of a hostile, we don't tolerate a hostile work environment. We also have many other rules, and maybe this is one of them where we don't charge that because we know that the spirit of that lawsuit was antitrust and making someone responsible for some fee that maybe we don't have the authority to prioritize. Anybody have any comment on this, or have had experience with this as an issue?
I mean, I'm just glad you're speaking on it because I have been wondering it myself. Like, I feel like I did hear you say something before where it's like you guys, oh, I think it was in a WhatsApp chat. You guys said don't do it. But I've seen, you know what I'm saying, how you said other people doing it. I'm like, well, they're
Right,
doing it. People are doing it. So the fact that you're addressing this whole point, I'm happy to hear about it.
right. And as I said, you may find that there are still properties that are closing now, right? That had this written into that, seller's agreement, at some point before it was taken off the form. So now it's not on the form. So it probably you'll see less and less of it. But, it very well may be that, I don't know, the company had always done it that way. This is this is one of the things. It's like, well, we've always done it this way. Well, okay, uh, I hear you, but at this point in time, is the $200 or the $100 worth, the risk of being sued? And this happened to one of our agents, and she just paid it and said, I'm not going to fight over it. I tried to find it written down somewhere, and I couldn't find it written down anywhere. So I assume I thought it was a law. I thought I saw it written down somewhere, but then I went in to look for it. I couldn't find it, and I haven't found it either. When she brought it up, I looked into it and I said, uh, let me see if it's in there. And the only thing that I could find really is sort of that broad concept, of imposing fees on someone, when you really don't have the authority to do that, and that's considered an antitrust violation. Antitrust is a big deal in real estate, and so we want to steer clear of that as much as possible. Uh, this is the basis for that NAR lawsuit, the antitrust issue. And so we want to steer clear of that and make sure that, we protect ourselves and protect our company. Um, and I don't know that it would cause you financial harm, or the company financial harm. We have insurance for this kind of stuff. But look, I mean, Keller Williams International paid out a couple hundred million to settle the lawsuit. National Association of Realtors paid almost 400 million. So these are big numbers, and we may only be getting pennies. But if we get sued, we're going to be sued for millions. So we want to steer clear of that. Okay. So the next topic, and I only have really two topics today, so if anybody has anything else, please chime in. But the second topic, and this turned into like a really huge discussion last night. It went on for hours, really. This is the after the event. A couple of us um, were hanging out and talking about this, and I would say that the key protagonists in this discussion were number one, an experienced real estate agent from Pennsylvania, and number two, a New Jersey attorney, and me. So we had this discussion, and I was shocked, kind of, because and some of you know I'm licensed in Pennsylvania, and Pennsylvania is a no attorney state. So we don't use attorneys in Pennsylvania. Now, South Jersey doesn't use attorneys. North Jersey, wherever you draw that line, uses attorneys. So once you get around, Mercer County, you never know. You might use an attorney, you might not use an attorney. Have any of you done a closing without an attorney? Anybody?
I would never.
I would never.
I would never.
That's a good answer. Yeah. So I of course have Pennsylvania experience, and I would say that I felt very uncomfortable throughout the whole process. So the Pennsylvania real estate agent says, we love it this way, and if you talk to somebody from South Jersey, they say, we love it this way, without using attorneys. They're used to not using attorneys. I remember one of my students in the classroom said, I said, she works as a admin, so unlicensed assistant to a team in South Jersey. And I said, let me ask you a question. I said, on the first page of the document that we use for writing up offers, it says you should use an attorney. If you don't use an attorney, you're putting yourself at risk. And it's attorney, 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 attorney. It's like 17 times they tell you how important it is to use an attorney. And I said, when you sit down with someone to sign that offer, how do you skip over all of that stuff that says you should use an attorney and say, we don't think you should use an attorney? They said, we tell them that attorneys mess up the deal. They mess things up. And she goes, ooh, maybe I shouldn't have said that. I said, you think? So, because it's really contrary, to what's called, it's opinion 51, is it? Or 53, 51? So it's a Supreme Court decision in New Jersey that says that real estate agents should encourage the use of attorneys in a real estate transaction. So this is not some willy-nilly policy that was generated by some bureaucrat. This is a Supreme Court decision in New Jersey, and we say we should use an attorney. And you don't have to. You should use an attorney. And why? Right? Because we know that there are very many legal things that come up, in the course of a transaction like the ones we do every day. And boy, it's nice to have a set of eyes that have a legal background behind them, right? To help troubleshoot. And here's the other thing, a lot of you have seen the fire extinguisher behind the glass, and they say, in case of emergency, break glass, right? And grab the fire extinguisher. Well, it's really nice to have that real estate agent, that the lawyer on your team, because in case of emergency, you want to break glass and bring that person into the forefront and show their teeth if they need to, threaten to sue or take them to a judicial review if necessary. I had a guy that wouldn't return his security after we killed the deal. Return it was only $5,000, but 5,000 is 5,000, and the guy would not return it. we had to threaten to go to the Attorney General office and file a judicial review because this guy was not acting appropriately from an ethical perspective. And, do we know how to do that kind of stuff? I don't. I mean, I know a lot of stuff, but I don't know that kind of stuff, and so a lawyer knows how to use leverage, and hopefully they're tactful in the way that they communicate and use language that is going to get the attention of the other attorney in the deal and make things happen. So anyway, so if you have an attorney involved, you can do stuff, right? Maybe we have an amendment to the contract we want to do. Now, can you write up that amendment and have both parties sign it? You can, but isn't that acting in the place of an attorney? And if you look through the enforcement activities pages of the Real Estate Commission, you will find examples of people who have acted as an attorney, as a real estate agent, and they were fined $5,000, made to take courses, maybe had their licenses put on probation, right? You can be put on probation, you can be suspended, you can be revoked, but maybe suspended, for doing something like that. Now, when we fill out forms for a real estate transaction, there are 50 or so forms, right, that are available to you through the New Jersey Association of Realtors, right? NJAR. And where do those forms come from? These are forms that were created by attorneys, okay? Real estate attorneys, people knowledgeable about real estate law. And what they do is they create a form that we just have to fill in the blanks, right? The form is legal and conforms to all the real estate laws that are out there. So we are only able to do our job using those forms that have been vetted by attorneys, that have been created by attorneys, that are fill in the blank kind of forms. Now, if we decide we're going to go off the reservation and rewrite our own contract, we take a risk because we do not have that filter of all of the real estate law, and we're not lawyers, so we can perhaps write a contract that isn't legally valid and legally binding, and then could mess up the whole deal if someone were to question it. So that's why we use the forms. Now, so let's say you're writing up an agreement about something. You agree to, I don't know, include some chattels. You were gonna take the pool out and the shed out and move it to your new house, but you decided that's too much trouble. We're just gonna leave it. So you're going to change the contract to include, those items. You could write that up and have both parties sign it, but is it written up in a way that's legal? Now, it doesn't sound like it's that complicated a thing to write up, but how do we handle that? We tell the lawyer what we want to do, and the lawyer writes it up, and then we might circulate it for signatures. But again, anytime you're writing an amendment to a contract or you're modifying the contract in any way, you need to make sure that it conforms, to those legal standards. So this, drew a lot of debate, especially on behalf of this agent from Pennsylvania. And again, there's the phrase, well, this is how we've always done it. We write up amendments to contracts. We rewrite sections of contracts. We cross out things in contracts. Now, there's no lawyer involved in that contract on either side of the transaction. So they've sort of been doing it this way forever and without, I guess, major consequence, you probably go through your whole career, and do this. So I'm not saying it doesn't happen every day without consequence, but boy, if there was a situation where the wheels came off the wagon, and the likelihood for the wheels coming off the wagon exists in every one of our transactions. You want to bulletproof your transaction. You want to make it as solid as possible. And so when you start to write up, contract components and take on that responsibility for yourself, the likelihood of a mistake, being made is certainly possible. So we want to make sure that you don't run into that problem. But I will tell you, the attorney and I were taking one side, and this Pennsylvania agent was taking the other side. And when you find somebody who's been working in that no attorney necessary environment, they develop a very strong opinion about, how they're going to manage that transaction. They do have a lot more control over the transaction. The attorneys are not involved in strengthening things or messing things up. They're just not involved at all. And so what happens is the agent, internalizes more and more authority, inappropriately so, I would suggest, because they're basing it on, their attitudes and their opinions, but not through that legal filter, which is so important in the transaction. So, I'm not sponsored by the law firm of Fetko, and Fetko here today. I'm just saying that, boy, I sort of wholeheartedly endorse Lawrence's response, which is I would never do a transaction without one. And those of you who have been through transactions without an attorney, know what I'm talking about. Every time I do a Pennsylvania transaction, I'm like, I have to second guess myself. I say, now I feel comfortable. I know what I'm doing, but it's like, am I doing this right? I second guess myself probably way more than I might normally. And I think it's a good practice to know what you're doing and to have someone to lean on if things get crazy. So that's that. So those are the two things that occurred to me after I had set the agenda for this meeting. So what I planned to talk about actually was, just the changes in the law, and to see if anybody had any questions about this. We had some real herky-jerky motions last year. We had to have flood condition disclosure. I don't know about you, but I mean, I feel like most real estate agents don't understand, flood designations, and they don't know the difference between AE and an E, an A, and an E. It's like there are different issues with disclosure that came up last year. First, they said you had to disclose flood, but then we didn't have to disclose anything else. What's up with that? So, and now they change it and say, oh, the people were just filling out the disclosure form where it's, the flood section was. And that was ridiculous. So now they said, okay, you have to fill out the whole disclosure form, including flood. So I remember I said, well, if I'm going to go through all this trouble, I'm going to, when I do a listing, I'm going to search, the flood status. I'll print out that little 2-page thing from the Department of Community Affairs, or EPA, Environmental Protection, and DEP, Department of Environmental Protection, DEP is the state one, right? And they have created this new website you can go on very easily and crank out and so I post that onto the listing. And then, of course, one of the first calls I got was, I noticed you posted the flood status of the property. Is there a flood problem? I'm like, what? No, I was letting you know that there wasn't a flood problem and providing you with that information that you're going to need anyway. So I just stopped doing that because I realized that it raised more questions than answer questions, you know. But the bottom line is that we now have a disclosure that's about. Now, a lot of sellers don't like filling these out. They don't know how many, amps their electrical services. They don't know anything about anything. I have a funny story about that. One of my students, we were talking about HVAC, systems. And she said she had to go and ask her husband, she said, do we have one of those in our house? And he opened this door in the basement and showed it to her. And she's like, I never knew that was here. So, you have all ranges of expertise, in these things. So, but the bottom line is, if you're in real estate, you should be able to relate, you should be able to help people understand stuff. I just had an inspection, and the house is wired with aluminum wiring. Now, aluminum was used in the 70s when the copper was really expensive, and there's nothing wrong with it, except if you bridge onto aluminum with copper. At that point of connection, you could have heat and potentially a fire. So you have to use a special connector it's called a pigtail evaluation. So it's a $3 item, and it plugs in the copper to the aluminum, and it keeps it from getting hot and causing a fire. Well, this agent that's reviewing this house says, the inspector says there was aluminum wiring, and we need to have that fixed. We need to have what fixed? You want me to rewire the whole house with copper or what? You know, when you disclose stuff, you have to sort of hope that somebody has some baseline understanding of how these things work, or you have to be able to educate people about this. So with disclosure, it comes knowledge. You have to have a certain amount of knowledge to explain stuff to people, especially if there's something quirky and weird, like I just described. So I always suggest, for people who are new to real estate, maybe don't feel completely confident or comfortable, to go to Home Depot or Lowe's and buy one of those books. It's like 12 chapters, framing, electrical, plumbing, right? One chapter on each topic. Now, you don't have to be an expert. I'm not going to make you build a house after you read the book, but get that baseline information, understand. And the other thing is super important. Follow the inspector around when you have a home inspection and ask questions. That's the best way to learn about stuff, especially if it's a good inspector, not this inspector that didn't understand aluminum wiring. But, and there are two things on his report. He said that there was a leak on the pipe. So $200 to pay a plumber to come out and look at the leak. There's no leak. Hello, $200. What a waste. So you should be able to have some baseline information about all of the stuff that goes into a house and be able to educate sometimes, because everybody is not going to be coming, from the same place. I'm actually building a house right now, so it's like I'm so mired in details. It makes me crazy. But it's important to understand at least broad strokes. Okay, how are we doing? Okay. There was some other stuff here. I hesitate to open up this conversation, but let's talk about compensation for maybe just close it out with compensation. There's all kinds of models out there for figuring out how you're going to get paid as a buyer's agent, right? I had one, I had five offers for this property them selling, and the one agent said, I said, I'm paying 2.5% out, right? We're paying 2.5% out. And she wrote in the section for compensation, she wrote, um, in order to sweeten the deal, she didn't use these words, but in order to sweeten the deal, I'm willing to accept 2% compensation, thereby saving the owners, and I forget, she had written the number down, $3,000, whatever it was, $3,500. And I thought to myself, well, there's an interesting strategy. We've heard about, like, writing in your own compensation as part of the offer, right? But have we talked about lowering the amount of money that you're willing to accept for being a buyer's agent, lower than the amount that's offered, you know? And then we see people that say, I don't care what you're offering. They don't even ask you what you're offering. They just write in like 4%. And then that becomes something that, if it's a good offer, that becomes something that you're going to negotiate, you knock them down to 2.5% or 3% or something like that. I talked to a gentleman who's a very experienced agent, and he started writing in 4% on all of his offers. I said, well, what if they tell you they're only paying 2.5%? He says, I don't care. I just write it in. They want my offer, they're going to pay me 4%. So he just ignores whatever it is that they say that they're offering. And I said, how's that working out for you? He says, well, I'm averaging over 3% after negotiation. His average compensation is now over 3%. I said, interesting, interesting. So we're all worried about, our buyer's agency agreement and how that's written. And what if we say we'll only, take what they're paying, and then they're not paying anything, or they're paying a $5,000 flat rate or something like that. Are we hurting ourselves by writing these contracts up the wrong way? And I always say, you know what? Think about your knowledge of contracts. What do you know about contracts? Contracts can be changed, right? If both parties agree to change the contract. So let's say,
If I have a question here
Yeah.
regarding the compensation that you just talked about.
Yeah.
So let's say you are putting a higher percentage, 3 or 4 or whatever it may be.
Yeah.
But that would necessarily work in a scenario where there aren't too many offers, or maybe just one offer that you're competing against. Don't you think? Because if there are a lot more offers, and like you gave the previous example of the agent saying, I'll cut down from 2.5% to 2%, wouldn't that matter? Because at the end of the day, it's what the seller nets, isn't it?
Right. And so that's the perfect, you answered your own question. What if your offer is 50,000 higher than all the other offers, and it includes a 4% compensation for the buyer's agent? So they're going to collect $50,000, and then maybe have to pay out another $3,000 or $4,000 to you as a buyer's agent. That still works in your favor as a buyer's agent, right? So you just have to really determine, how strong your offer is. You wouldn't go you wouldn't offer, 10,000 under asking price, and then put a 4% buyer's agency fee on there, right? But if you were 50,000 over, or 100,000 over, or 80,000 over, you very well may, put a higher percentage on there and get paid, for sure.
Okay, thanks.
Yep. So in general, we're talking about the buyer's agency agreement is a contract of sorts. So it is a contract. It is a binding contract, actually. However, if both of you agree to tear it up, you can tear it up and rewrite a new one. So what if the contract is written for 2.5%, and the seller's offering 3%. I say, with the uh, concurrence of your buyer, you change the contract from 2.5% to 3%. Now you could either mark it up and initial it and date it and sign it, or you can tear it up and rewrite a new one. Because your knowledge of contracts says that if you have a contract and it's been signed, it's a binding contract. If you want to change it, you can change it with the concurrence of all parties. So that means you can tear it up. That means you can rewrite it. That means you can change any element contained within that contract. So don't feel like, these contracts are carved in stone. And I'll tell you what, if you have I heard from another agent recently, there was a buyer who this agent was working with, and then they said they want to tear up their contract. And the agent said, I don't want to tear it up. And then the ruling from the real estate commission was that they don't need your permission to get out of this contract. And I thought, well, it's a binding contract. How is that possible? And a lot of times you write these things for a year. I have a couple I'm working with. They're looking in Pennsylvania and in New Jersey, and I have 2 buyer's agency agreements with them, and we wrote them for a year because we know how difficult it is to find something, in their price range. And so they're precluded from working with anybody else for a year. I was sort of surprised that they signed that with me, but I said, look, this is going to take some time. I'd like to write it for a year, and they were okay with it. So, you'll see all kinds of different things. But I guess the point I wanted to make is that maybe these buyer's agency agreements are not as strong, as the state would lead you to believe. Because if you could walk away from that buyer's agency agreement by just sending a letter to the agent saying, I want out, is that really a binding contract? I mean, it seems like maybe the answer is no, but all throughout that buyer's agency agreement, it says that it is a binding contract. So I'm a little bit confused by that. So if you are confused by that, I think you're in good company. So that's pretty much all I have today. I don't know if anybody has any questions on any topics. We should call this the cocktail hour conversation or something, but what are those things that are an issue for you all today and from month to month, it's kind of a good thing to think about. What are those things that are a little bit confusing, or that, we're always meaning to get around to looking up, the answers to these questions and trying to figure out what the right thing to do is. We all want to do the right thing. Sometimes we can't find what that answer is. We're surrounded, by all these rules and regulations and policies. And so it does create confusion sometimes. So it's important to talk about it, to reflect on, what are laws, what are rules, what are policies, and try to do, the right thing. I think that's the goal every day, right? We get up, we try to do the right thing. And so hopefully, we do the right thing more than we do the wrong thing. That's what it comes down to. And there's ethics involved as well. So sometimes when we don't have something written down, this is the law or this is the right way to do it, we have to do what's called policy interpolation. We have 2 policies and we say, okay, so if this is true and this is true, then, we have to make a decision on what the next thing is. It's sort of in between those 2. We can sort of figure out what the right thing to do is by reflecting on those rules that exist for those other policies, those other issues. So that is it. Anybody have anything they want to mention or bring up? Lawrence?
My brain is ringing right now with just all the information that you just gave.
Okay, good, good. All right, great. Well, I'm very happy to have been here today and to share what insight I have. And as always, if anybody has any questions, please reach out to me. I'm happy to help you figure out the answer to the questions that come up on a day-to-day basis. Okay.
Awesome.
I had a quick question.
Sure.
How
Go
you
ahead.
mentioned a book. Is it like a home improvement book? Like you said, something on all the topics so that we know, like framing, wiring, like because
Yeah, yeah.
while we were on, I just tried to go on another screen and say, okay, what book should I get? Is
Yeah,
that
just go. You know what? I would suggest. I'll tell you what I do. This is hilarious. Is that a lot of people get these as gifts? You know, when they get their first house. So when I go to garage sales, I look for these books, and I find them at garage sales all the time. And uh, I'm unhappy to say that most people have never even taken them out of the cellophane wrap that they're in, and they just sell them for $5 at their garage sale. That somebody gave it to them as a new homeowner or something like that. So I pick them up and then I give them to new homeowners. When I have a buyer that's like a first time homeowner, I actually give them out. Hopefully they'll read it, but I found them at garage sales. But it's simple. Like a chapter on HVAC, is one on electricity, one on plumbing, and so yeah, it's just like a 12 chapter book, and you might have to look around for them, or maybe look online, but they do have them, or look on Amazon, maybe see what they have. But I found them to be very helpful. I've read a few of these myself, and they give you some little insight into things, you know. And I can't tell you how many times I've been like told a line of baloney by an agent. I said, well, how come all this sheetrock in the basement is cut up 24 inches? When did you have a flood? Oh, we didn't have a flood. We were just doing some electrical work. And I'm thinking to myself, liar, you're a liar. And there's nothing in the disclosure about water in the basement or anything else. But I mean, most of us have seen that, right? Where they cut the sheetrock up 2 feet so that they can replace it because the capillary action, water gets sucked up into the sheetrock, right? Through capillary action. And any of you can remember that from science, you put a piece of cotton in a flask and it empties out. It's like, how did that happen, right? So it's like, and they should know, but they
Yeah.
don't, and they just don't want to tell you. Oh, yes, there was a flood. Yeah. All right, come on, relax. It's not the end of the world here. So actually, I listed a house, like a $1.4 million house, and I went there and I was did the same thing. I said, when did you have water in the basement? Because the sump pump stopped working. We had a power outage, and now I got to replace all this. And I'm like, yeah, okay. Well, he was at least upfront about it, And so it's important to share that information, And so the more you know, the better off you're going to be, the better you can represent your clients, and the more successful you'll be because people know your stuff.
Yeah. Jeff, do you know the name of the book?
I can't think of it off the top of my head, but
Okay.
If you go into Home Depot, they don't have very many books there, but if you go into Home Depot, you'll find it for sure.
Okay.
Or ask about it.
Okay. There we
All
go. There's your tip.
Yeah. More reading.
Awesome. Well, thank you, Jeff, for coming on today. I appreciate all of you joining us for another spotlight session. Next week, we have Hercules Septic. Also, next week, we have the photo shoot. So if you have not already RSVP'd, please RSVP to that number that's on the flyer for the photo shoot. That's going to be Wednesday at 11 to 1. So I look forward to
That's
seeing you all then.
my friend Raina, right?
Yes, Raina. Uh-huh.
Yeah.
Yep.
She's a great person. I sold her a house 10 years ago, maybe. She's
Okay.
very, very good, very nice person. Yeah.
Yeah, I'm also going to have her on for a spotlight on flood insurance.
On insurance, yeah.
Uh-huh.
I think she's very knowledgeable about all aspects of insurance. Very knowledgeable. Yeah.
She's great. Awesome. So thanks, guys. You all have a great weekend.
Thanks.
Thanks.
Okay, bye, everybody.